on to our podcast, which considers the impacts of the coronavirus and remedies for construction from the Australian perspective. We are dealing with slides 1 and 2. Over the last several weeks, our firm has been fielding a number of calls from clients in the commercial and construction sectors who have expressed concern about their business in light of the ongoing Covid-19 pandemic. They are seeking to protect their own commercial interests and maintain a viable business. So, as several of them have said to us, the business can survive and reach profitability at the other end. In other words, when the virus ends and the social distancing is concluded. At the same time, the clients are also concerned about trying to maintain their existing business relationships. For those who are supplying services in the construction and commercial sectors, they are anxious about maintaining their cash flow. They are also anxious to maintain existing relationships with clients. Those two issues at the present time are diametrically opposed. There are some businesses and sectors which have been shut down. So people have been let go and people are not able to gainfully be employed. That also has restrictions on how people do business, how they hire and recruit specialised labour that is useful to conduct their business in this particular environment. For those clients with existing supply lines and current financial responsibilities, in many cases they have already agreed on the terms of their commercial contracts. The benefit of a contract, as you know, is that contracts assist to establish and develop a business. Ongoing cash flow helps the business owner hire staff, establish business credibility with financiers and clients, and maintain their presence in their own commercial sector. It also assists them to gain new work. In more normal times, the usual pattern of daily life is complicated and creates its own anxieties. However, the current situation has only worsened our commercial and personal anxieties. We're now considering slide 3. As we know, the federal and state governments around Australia have passed legislation which is designed to protect the population. They have also introduced a number of initiatives that seek to minimise the effect of the virus. As our government leaders often remind us, it is also about protecting the economy. As an example, a number of measures have been introduced by the state and federal governments to seek to lessen the impact of the virus from a macro and microeconomic perspective, and also to try to minimise the societal distancing one from another. This has been effective to date. The key amendments that have been introduced may be seen from the New South Wales Government, which on the 24th of March introduced a Covid-19 legislation amendment, Emergency Measures Act 2020, which amended a number of acts which were designed to implement emergency measures as a result of the pandemic. The key features of these amendments are that they are emergency measures. They have been introduced to protect the health, safety and ongoing welfare of the public. That said, they are also temporary in that they have been introduced for 6 months from the date of commencement. In addition, the federal government has introduced its economic stimulus package, which was effective 23 March 2020 through the Coronavirus Economic Response Package Omnibus Act number 2, 2020. The key measures of this Act were that the government has passed economic stimulus package which will benefit some 6 odd million Australian workers by guaranteeing an ongoing payment of a proportion of their weekly salary for a period of 6 months. We're going on to slide number 4, headed Options for Clients. So the question is, what options are available to contractors and commercial clients faced with various difficulties performing a contract. They may be faced with site closures. They may be faced with difficulties delivering services in the current climate arising from labour or supply shortages. The answer to this question is that it is complicated and impacted by a number of factors, many of which are beyond our control. These factors will ultimately be determined by reference to the individual contract or agreement which have been negotiated between one commercial party and another. We set out in the following slides commonly asked questions and our suggested responses to these issues. Dealing with slide number 5, headed Delays, Can We Claim an Extension of Time? As we said earlier, when there are delays in any contract or arrangement between one party and another, the rights of those parties will depend on the wording of the contract. Essentially, a contract is an agreement in writing signed by the parties, which sets out their various rights and obligations, normally one supplying a various good or service and the other agreeing to pay for that service, dependent on time and quality, and also for an arrangement whereby that there may be a situation where the contract might be ended through various conduct of the parties. The answer on whether we can claim a delay or whether an extension of time is available will be determined by the contract, whether the contract refers to a change of law and government requirements, which impacts a contractor's ability to perform its obligations. These obligations typically allow a contractor to claim an extension of time and compensation for additional costs incurred as a result of the change. An extension of time. This is where the contractor is delayed in performing works by a specified event of delay. Depending on the wording of the contract, the contractor or service party may be entitled to an extension equivalent to that delay. That said, usually the contractor will need to comply with a prescribed process set out in the contract to claim an extension. This will mean, for example, giving notice, normally in writing, to the other party about the delay. This will also then be determined by the contract superintendent in a construction setting to determine whether an extension of time is permissible. This will again be determined on the contract. A further potential right may arise in the form of delay costs. These arise where extra contract costs are incurred by the contractor as a result of an extension to the period for performing work. Delay costs may be recoverable as permitted by the contract, or at common law, in other words, if a court determines, for example, it may include such things as the hire of plant or loss of profit, which has occurred as a result of the delay. Slide number 6. Can we delay doing the work and do it later? I'd like to consider this scenario as an example. One of our clients, responsible for making and installing cladding products on large-scale residential and commercial sites, has approached us, concerned as to whether his workforce will come into contact with other workers on building sites and thereby be exposed to the virus. That client's company has been trading for more than 20 years. He's mindful that he does not wish to expose either himself or his workforce to the virus. This may lead to a loss of skilled labour. It may lead to his needing to find alternate qualified workers, which will be difficult in the current environment. The current situation arising from the coronavirus means that it is almost impossible for the parties or governments to assess the length of any delay which might arise to a contract or an employment setting, or whether there will be an end to social distancing and at what time. From a contract setting, the answer is whether a person may grant an extension of time or seek to take over the work if a person cannot perform it? This is a difficult question. Depending on the terms of the contract or the agreement, a claim for a delay may be made. If so, consider providing prompt notice of the delay as set out in the contract. Also consider whether there is the need to maintain the commercial relationship, seeking to reach an agreement with the other party having given notice of the claim, whether it may be possible to reach an agreement with the other party which will understand that performance might be difficult based on the current scenario. Part of this alternative arrangement may be appointing an alternative supplier. The principal or the head contractor may take the work out of the hands of the head contractor or subcontractor respectively. It may also delay or lessen the supply obligations. Slide number 7, headed "We do not want to end our agreement." What are the alternatives? The answer is it will depend on the agreement itself. For example, one right may be suspension under the contract. Suspension means temporarily ceasing or stopping of a person's rights and or obligations. The contract or agreement will remain in place until the circumstances leading to the suspension cease. Usually contracts provide a right to suspend where one party is in breach. However, there are some situations where the contract may be regarded as incapable of being performed for events beyond their control. An example of this was found at the end of March, on the 31st of March, in the Age newspaper, which reported that Multiplex's $2.8 billion Melbourne Square worksite at Southbank was closed and will be reopened after cleaning. 20 work colleagues were placed under self-isolation after one worker was found to be positive for the virus. This is an illustration that while the site is shut, the contract cannot be performed. Neither party can perform its part of the agreement. The rights of the parties will remain suspended until the event that leads to the event ceases, for example, where the site reopens after it has been cleaned and certified as safe. So suspension is one means available in the event that a party feels that it cannot perform its part of the contract. Slides 8 and 9, force majeure. A further option available to a party faced with the impossibility of performing its contract or bargain is force majeure. This means an event which is beyond the control of the contracting parties and which prevents the work from being carried out or makes performance of the parties' obligations impossible. This may include natural disasters such as flooding, earthquake, cyclone, war or industrial disputes. I've included in the slides an example of a force majeure clause. These are not often found in many of the Australian standard building contracts. However, the purpose of this clause that I've highlighted in the slides specifically defines epidemic, which would certainly be caught within the current environment. This clause specifically refers to an epidemic which is not related to the acts of the subcontractor. So this clause could be used as a basis to suspend that party's rights under its contract. I've also set out in the slides another specific example under the MW21 General Conditions of Contract, which specifically defines a number of events which may be categorised or defined as force majeure events. Clause 1.11 refers to epidemics or pandemics beyond the control of the contractor or principal and which could not have been avoided or overcome by the parties taking all reasonable steps. So, the reason I have included reference to these specific clauses, both of which refer to an epidemic or pandemic which is beyond the control of the parties, is that this is a very good illustration of a force majeure clause. In that instance, the event which prevents or makes impossible performance of the parties' obligations has arisen, which is 1, beyond the control of the parties, and 2, could not be said to be the result of their activities. Full stop. In this event, if there is a force majeure clause in your contract or an agreement, take care to read it carefully. If it does provide for a specific right for you to suspend works under the contract, you should consider the following. What does the contract say about giving notice to the other party? Second, the events that should occur before notice, in other words, to seek to bring yourself within the terms of the contract provisions. Secondly, consider the consequences of giving notice, of being able to rely on the force majeure rights. Fourthly, what reasonable actions have been taken to lessen or mitigate the loss or overcome the effect of the force majeure event in terms of a party's own contractual obligations? The reason I raise this fourth point is because courts are very much inclined to let the parties' contract rights remain. They are very reluctant to seek to overturn a contract or an agreement which has been agreed and signed by the parties, provided they have equal bargaining rights. That said, the court will always expect or will ask of the person that is suffering loss or seeking to make a claim for delay or damages for loss as a result of a particular event, what actions they have taken to seek to lessen or mitigate the loss. They will need to demonstrate that in coming to court, they have sought to not only lessen the loss, they have sought also to actively take steps to do that, to preserve their commercial position. In other words, to show the court that they have understood the terms of their contract. Secondly, they have sought to rely on or seek to get other parties involved to seek to lessen their economic damage which they are claiming. If the fundamental objective of the contract cannot be completed because of the impact of the virus, for example, it may be time to exercise the force majeure clause if you have one, or notify the other party that the contract is entirely frustrated because of that particular event. That said, always consider what the impact this course of action may have before deciding to make a claim for force majeure under the contract. Slides 10 and 11, order the disputes keeps going. Thus far we have been considering trying to do our best to maintain the commercial relationship. However, the longer a dispute proceeds, the parties should carefully consider whether the effect of that ongoing dispute may be to end the contract. An example of this is frustration. This occurs when an unforeseen, uncontrollable event, when no party is at fault, renders the parties under the contract incapable of performing their obligations. Frustration occurs where the contract is rendered pointless, is illegal, or the foundation of the contract no longer exists. The frustrated party is entitled to rescind the contract without being liable to the other party for damages. The parties are not required to wait until an event or effect happens to their contract before they decide to end it. Determining the length and the effect of the delay is to be made at the time of the interruption of the contract. The Australian standard contracts provide for the works completion, for the party responsible for carrying out the works to take care of the works, and also ensuring that there is adequate and appropriate insurance cover in place to cover damage to the works and damage to other people. Unless specifically amended in the special conditions, there is no specific protection for risks of loss or damage arising as a result of an epidemic. Instead, the contractor shall issue progress certificates as the work progresses. If the contract obligations cannot be performed, the contract may be seen as being frustrated. If considering relying on this particular provision, consider the following: claims evidencing the amount or the amounts which would have been payable had the contract not been frustrated. Secondly, the cost of materials and equipment reasonably ordered by the contractor for the construction work, and those costs reasonably incurred arising as a result of the specific event which has resulted in frustration of the contract. We're dealing with slides 12 and 13. The next several slides deal with what events provide for an end to the agreement. This is termination. Termination means ending the contract or the contractual obligation in question. Usually contracts will specify when the contract or the agreement may terminate. There are also common law rights that the courts may use or to intervene to end the contract. However, take care when considering whether to terminate the contract. Consider whether there are rights. Termination may arise in accordance with the terms of the contract, for example, where the parties' rights are frustrated, as we've discussed before. Secondly, termination may arise as a result of substantial breach. In other words, a party is in breach of its major obligations under its contract. These substantial breaches are usually defined in the contract. They, for example, may mean failing to pay money for services, failing to deliver a contract or goods on time, failing to deliver product in accordance with the various KPIs, or where, for example, a party proceeds into liquidation. Before considering whether to terminate the contract, consider the effect of the continuing obligations under that agreement. Consider whether there is any information or documents that need to be returned. Consider whether goods or assets would also need to be returned prior to termination. Importantly, these goods or assets may also include reference to intellectual property and other plans or drawings which have been given by one party to another, which should be handed back on termination. Dealing with slide 14, what happens if my contract is with a company or a person outside of New South Wales or Australia? We need to understand what the governing law of the contract is. This will determine what rights will apply to the parties and their obligations and performance. For example, GC 21 provides that the governing law of the contract will be governed by the laws of New South Wales, and the parties submit to the jurisdiction of the New South Wales courts. The effect of this contract is that any rights and disputes between the parties will be determined by New South Wales courts. On the other hand, if you are dealing with a company that's based overseas, check whether the contract provides which law will be the governing law of the contract and which jurisdiction. This will be essential to understand what rights you have to seek to enforce your rights under the contract against the other party. If you are seeking to enforce your rights in an overseas jurisdiction, this can be tricky. It can be expensive, and it can also mean that you will need to engage overseas lawyers to seek to enforce your rights under the contract. Slide number 15, insurance. Will my policy respond? A very good question. This will depend on your policy. And we've suggested in our paper, it is a very good idea as a starting point to call your broker. They will be able to give you first-hand guidance about whether the policy will respond to the loss that you are claiming. They will also be able to provide guidance as to the specific notice required under the policy, what applicable excesses there are, the limits of cover, and whether there are any policy exclusions. In other words, occurrences which may mean that there may be no coverage under the policy. In the construction and commercial fields where no damage has occurred, consider whether your business has business interruption cover and the terms under which a claim may be made. Finally, the current situation facing commercial parties is complex. It is also one that presents challenges as to how parties deal with each other and whether they are able to complete their part of a project, deliver their supply and service requirements, and the service the particular circumstances under which they may have certain rights and may choose to actively enforce those or seek to negotiate an alternate arrangement with the other party, thereby seeking to maintain their commercial relationship. If you have any queries arising in relation to any of these matters in the current situation, please contact our office and we'll be most happy to speak to you further and provide advice. Thank you for listening and stay safe.